to our summer form series. July is all about buyer forms. Moving right along, our next form is going to be our tenant occupied property addendum. This is also one that you might start seeing a little bit more. It should be, because anytime the property is not occupied by the seller, we want to include this tenant occupied property addendum. Okay, the TOPA, we call it the TOPA form. So anytime the property is not seller occupied, we want to include this form. Or if the seller occupies one unit, but maybe they're renting out or has somebody else living in the other unit, the ADU unit, maybe it's a multifamily housing, right? Whatever that might be, we want to use this form. So it's an addendum to the purchase agreement. Could be an addendum to a counter offer or other. We're going to put the date on there, the property address, the buyer's names, the seller's names. Buyer and seller are now referred to as parties for the purpose of this TOPA. Tenant shall mean any adult person other than the seller who is occupying the property, whether or not that occupant is paying rent. Okay. Now, this doesn't mean that my seller lives with the seller's wife and 2 kids, and so we have to present the TOPA for the wife and 2 kids because they're not on title. No, they're in the same household. That's totally fine. We just write a regular purchase agreement. This is, hey, the seller's aunt occupies the property and she's not paying rent, but the seller doesn't live there. Okay, the seller doesn't reside in that unit. Okay. Buyer shall take the property subject to the rights. Oh, so number 1 is tenants to remain in possession. So 1A is tenants remain in possession. Buyer's going to take possession. We're going to get keys subject to the rights of the existing tenants and other terms and conditions specified in paragraph 2. Okay, that means you're going to get copies of all those rental agreements. The deposit should be passed on to our buyers. Our prorated rents probably we want passed on to our buyers, right? So we want all that taken care of. And they're going to take the property as landlords. Okay. The next option, so that's 1A. 1B is an or, property to be delivered vacant. The property, right, if it's whole, shall be delivered vacant without existing tenants. Or if maybe it's like a 4-unit property and my seller or my buyer wants to occupy unit 2, then the property unit 2 shall be delivered vacant. Everything else will remain with tenants in it. Okay, so this might be where you put the property. You could say ADU unit if they're renting out that ADU, right? So whatever it might be, maybe it's got maybe it's like 769 and a half is the address, right? So whatever it is that specifies, that clearly identifies which unit should be delivered vacant, that's not seller occupied, we want to put them in there. Okay, so that's 1, property or unit should be delivered vacant. The seller, after exercise of good faith, attempts and subject to applicable laws, is unable to remove existing tenants by close of escrow. So, right, so if they're unable to get them removed, buyer may cancel this agreement, and buyer's sole remedy shall be the return of the deposit and buyer's reasonable out-of-pocket expenses for inspection reports and appraisal fees under the agreement. Okay, so that's the default there. So we could change that. We could say, hey, we want that tenant out before the close of escrow. Okay, not by the close of escrow. So we might want it 5 days prior to the close of escrow. That's usually a good practice. Then buyer may cancel this agreement. Right now, notice here it says buyer's reasonable out-of-pocket expenses for inspection reports and appraisal fees. So if seller can't get the tenant out, my buyer has the right to cancel, and they have the right to be compensated for what their out-of-pocket was for those inspections and appraisal fees because the seller's failing to perform. Now, if I'm a seller, I'm going to want this box checked right here, which the total amount shall be no more than what, right? So I might say, hey, my seller's willing to pay for stuff up to $1,000, or maybe we're going to say $1,500 because those appraisals are expensive. Right. I think my last buyers on a multi-unit property, we just closed on a 4-unit property. Their appraisal was like $3,500. Okay. Out of control. But anyways, so if I'm a seller though, I want a max put in here because I don't want to just be like on every whim of the buyer, they decided to have $3,000 worth of investigations and inspections done on the property, and their appraisal cost $3,500. So now they're going to come to me for $6,500 in the case that I can't get that tenant out. So I'm going to want a cap in here if I'm a seller. Okay. Or, so that's section. Yeah, go ahead.
So let's say I'm the buyer's agent and I left that blank, and later on we do cancel because the tenants did not move out 5 days prior, and I can cancel. Um, because that was left blank, would the sellers have to then agree on what, like, give us whatever dollar amount because they missed that part when it was delivered in the with the RPA?
Yeah, you
Would
would
they
need
be
to come to an
responsible?
agreement. Yeah, you would need to come to an agreement because it specifies here that the buyer's reasonable and out-of-pocket expenses for inspections, reports, and appraisal fees under the agreement. So you'd have to determine what was reasonable and with the seller, right? So now it's kind of going to get into a dispute. So it's really in everybody's best interest that you put something in here because now
Mhm.
we have a
Well, like if
number that
you
we can work
forgot, I'm
off.
just thinking like if I oversaw that part and I forgot to fill that part out,
Yes.
then
Yep.
then you can
Oh,
just, I guess, show all the receipts for the
yep.
inspections, the appraisal, and then give them that amount then, right?
Yep. Yep. Absolutely. You can ask for proof
Thank
for
you.
sure. Yeah. So that's right. So that's section 1 of 2. It says that hey, if the tenants aren't out, buyer
Only,
has the right to cancel. Yes, question?
yeah. So is this only if the tenants don't move out of the property that you
Yes, that's
would
only if
ask?
the
Okay.
yeah, yeah, because that's the seller's breach. The seller is now agreeing that they're going to get those tenants out 5 days prior to the close of escrow. So if the seller doesn't complete that process, then the buyer has the right under this agreement only to go and ask for reasonable money back for the cost of their appraisal and inspections. Yep. Okay. Now, section 2 of 2 says that, hey, the buyer doesn't have to cancel. The buyer can elect to proceed with the transaction with the tenants in possession. And by doing so, buyer's waiving any claim for other damages or compensation arising out of the tenants remaining in possession. So, right. So the buyer can still close. They don't have to cancel just because the tenant didn't move out. The other option is that, we can always ask for an extension of the close of escrow until the tenants move out, right? So we can remedy that if the buyer still wants the property. Usually the buyers actually want to close on the property, so we just have to find that workaround. So one is, right, property or at least a unit should be delivered vacant. Section 2 is that saying that, hey, with that, because we're asking for a tenant to be removed from the property, it needs to be empty either at close of escrow or 5 days before. Section 3 of that section is this: if the seller is able to remove existing tenants prior to close of escrow, seller's applicable shall disclose to buyer when the property became vacant, whether the tenant vacated voluntarily, and if so, whether seller paid the tenant to leave, and whether the seller filed lawsuit, unlawful detainer, to attempt to evict the tenant, and if so, whether the lawsuit ended in a judgment. Okay, so they're just saying that, hey, number 3 is tenant has moved out. Seller has to disclose to us whether that was like a friendly move out or whether, we had to take legal action to get that tenant out because the buyer is probably going to want to know that. If the tenant was forcibly removed from that property, then buyer may want to be aware that they may want to install cameras or something because the tenant may try to come back and retaliate. Maybe they didn't know it was being sold or there's a new owner, right? So we just want to know. So the buyer has a right to know how the tenants were removed. All right. And then 4 of this section is seller within 5 days prior to the close of escrow shall deliver to buyer the names of all adult occupants residing in the property other than the seller that are known to the seller, or the following are the names of all adult occupants other than the seller that are known to the seller. So they can disclose it at time of the TOPA right here. That's just saying that, hey, if there's still people in the property 5 days prior to the close of escrow, we have to disclose all of those names to our buyers so that they know who is in that property, who they're becoming a landlord for. Even if, pursuant to the agreement, seller remains in possession after the close of escrow, no tenants shall remain except blank, right? So we might have an agreement, a SPRP, maybe again, the seller occupies the main unit. Maybe there's a tenant in the ADU unit. We're asking for the property to be delivered vacant, including the ADU unit. And so even if we have an agreement where the seller is going to remain for a week after the close of escrow, the tenant should be gone. Okay, except we could fill in the line here. Maybe the tenant is in the ADU unit is the seller's grandma, and then you could put except ADU unit to be delivered vacant at the same time as the main property, right? So you could specify that in there as well. Any other questions on that 1B, the vacant section? Okay. The other time we would use this TOPA form is 1C, which is the buyer is a tenant in the property, right? Buyer occupies the property or units blank. Paragraph 2 of this TOPA form shall not apply for the property or units occupied by the buyer. Security deposit, seller shall transfer to buyer through escrow all unused tenants' deposits, if any, and all prepaid but unearned rents, if any, prorated at the close of escrow. Okay, so that's just saying that, hey, C is, and then B is specified here, maybe where the deposit's going to count towards their down payment. We could specify that here, right? So you could use B for anything. So that's, and then for any units not occupied by buyer, all other terms of this TOPA shall apply. So, right, so how often do we have transactions where we've got a buyer who's trying to purchase the property? It's not seller occupied. So we still need the TOPA form, but this gives us the option to use this buyer as a tenant in the property. They occupy the property as the default, or if it's multi-unit, you'd put in what unit here. And then you would leave that there, that through escrow, the prepaid rent. So that means like if we close in the middle of the month and buyer paid rent for that whole month, that unearned rent, so that remainder of the rent goes back to the buyer. Okay, so that's how that works there. So we've got tenants to remain in possession, property to be delivered vacant, or buyer is a tenant in the property. Okay. Any other questions there on section 1? All right. Our section 2 is tenant remaining in possession, additional terms. So anytime we have tenants who are going to remain in possession, so either one or maybe multiple units are staying, we're only asking for one unit to be vacant, or this, if its buyer is in a tenant in the property, 2 doesn't apply if they're the only unit. Okay, if they're one of multiple units, then it would apply for the remaining units. So tenant deposits and unearned rent, seller shall transfer to buyer through escrow all unused tenant deposits, if any, and all prepaid but unearned rents. Okay. If any, prorated at the close of escrow, seller shall disclose to buyer any tenant delinquencies. And you can check this box here. Seller shall credit buyer for any delinquent rent prorated as the close of escrow. Right? If one of our tenants hasn't paid rent yet, we still get the rent for the remainder of the month post close of escrow to the end of the month. Okay, so that's what that box allows you to do. If we don't check this box, only the current rents that are paid current get transferred over. All right, section 2, government compliance. No warranty is made concerning compliance with the governmental restrictions, if any, limiting the amount of rent that can lawfully be charged, the maximum number of persons who can lawfully occupy the property, or the ability of a buyer to remove any tenant from possession. Buyers advised to carefully read and consider the attached rent cap and just cause addendum, car form RCJC, which may impact buyer and tenant's rights and obligations under the law. Buyers advised that local ordinances may also affect buyer and tenant's rights and obligations. C, proposed changes. Seller shall give buyer written notice of any changes to existing leases or tenancies, any new agreements to lease or rent, changes to the status or condition of the property, proposed changes at least 7 days prior to any proposed changes. And then 2, buyer shall within 5 days after receipt of the notice of proposed changes give seller notice of the buyer's objection to the proposed changes in which the seller shall not make the proposed changes. What does that mean? Maybe one of the units is currently vacant and the seller's actively working to fill that. If we find a tenant for that property, the seller actually has to make the buyer aware once we're in contract of those changes, who the new tenant is, what the rent's going to be, what that contract's going to look like. And the buyer has the right to say, yep, go ahead and sign it. Let's get that tenant in place. Or no, I don't want to put that tenant in there as long as it's during the escrow period. So that's what those proposed changes are. Or maybe there's a rent increase coming into play or something to that effect, right? So any proposed changes, or that would also mean to changes to the status of the condition of the property, right? So any repairs, improvements, whatever might be there, those would be proposed changes as well. So that's section C. D is personal property included in the sale. A complete list of all personal property of seller currently used in operation of the property and included in the purchase price shall be delivered to buyer within the time specified for the delivery of documents in the agreement. Seller shall deliver title to the personal property by bill of sale, free of all liens and encumbrances and without warranty of condition, and as security for any note in favor of the seller for any part of the purchase price. Buyer shall execute a UCC-1 financing statement to be filed with the Secretary of State covering the personal property included in the purchase, replacement thereof, and insurance proceeds. That's just for seller financing. So for the most part, we don't have to worry about that. But they do need to provide a list. So maybe they own like the coin-op laundry equipment in like a fourplex, or maybe they have the washers and the dryers or the fridges in each of the units. That would be personal property. So they would just deliver to you a list of what that is. Let's see, that's section 2. A D there. Oh, the other thing that I'll make note of is up here on 2A with the prorated rents and the deposits transferring over to the buyers. Just tuck this away in your brain, because in the one that I had, this just came up. We transferred over all those deposits and the unearned rents, right? The prorated rents. And we also had negotiated a closing cost credit. Okay, well, my lender came back and said that the prorated rents and the deposits counted towards the total amount of the credit that the buyer could receive, and it made a mess of the credit that we had negotiated. So just kind of keep that in mind, that you always need to check with your lender before negotiating credits when we have a tenant occupied property, to check and see if those prorated rents and the deposits are going to count towards seller contribution or not. Okay, just throwing that out there. All right, section E, seller documentation and additional disclosure within the time specified in the agreement for seller's delivery of documents and subject to buyer right of review. Seller shall disclose or make available or deliver as applicable to the buyer the following: rental service agreements, current leases, rental agreements, service contracts, and other agreements pertaining to the operation of the property. A rental statement, including names of tenants, rental rates, period of rental, date of last rent increase, security deposits, rental concessions, rebates, other benefits, if any, and a list of delinquent rents and their duration. Seller represents the documents to be furnished are those maintained in the ordinary and normal course of business. Okay, so those should get passed over to the buyer for review as part of seller documents. We can check the box here for number 2 for income and expense statements. This is a good one too. The books and records for the property, if any, including a statement of income and expenses for 12 months preceding the acceptance. It's usually a good one to have in there. So you make sure that you know what they're paying for insurance and cost of maintenance and all those different things in there. Tenant estoppel certificates, I usually check this box, number E3. It's 2E3 technically. Tenant estoppel certificates shall be completed by seller or seller's agents, delivered to the tenants for tenants to sign and acknowledge that tenants' rent or lease agreements are unmodified and in full force and effect, or if modified, stating such modifications, that no lessor default exists, and stating the amount of any prepaid rent or security deposit. Seller shall exercise good faith to obtain tenant signatures, but seller cannot guarantee tenant's cooperation. In the event seller cannot obtain signed tenant estoppel certificates within the time specified above, seller shall notify buyer and provide the unsigned one that was provided to the tenant. If after the time specified for the seller to deliver the TECs to the buyer any tenant sign and return a TEC to the seller, seller shall deliver a copy of that TEC to the buyer. So again, I usually ask for those tenant estoppel certificates because it just states at that point any changes that have been made to the lease agreements, and it makes sure that the tenant's in agreement and they know that, hey, we're going to continue renting to you. It's still in full force and effect moving forward. So I like those tenant estoppel certificates. 4 is survey plans and engineering documents. If in seller's possession, copies of surveys, plans, specifications, and engineering documents prepared on seller's behalf or in seller's possession. Permits. If in seller's possession, seller shall deliver to buyer a copy of all permits and approvals, certificates of occupancy, conditional use permits, development plans, licenses, and permits pertaining to the operation of the property. 6 is structural modifications. Seller shall disclose to buyer in writing any known structural additions or alterations or the installation, alteration, repair, and replacement of significant components of the structure upon the property. 7 is security deposits, an itemized and lawful itemization of all lawful deductions made from tenant security deposits, if any, and a statement of the security deposit remaining after any lawful deductions have been made, car form, sample letter, change of ownership, and security deposit allocation. So that's in your car forms library, there's sample forms. You'll find that one there. F is seller representations unless otherwise disclosed under paragraph 11 of the agreement or any other disclosure delivered to buyer. Seller represents that seller has no actual knowledge that any tenants have any current pending lawsuits, investigations, inquiries, actions, or other proceedings affecting the property or right to use and occupy it. Has any unsatisfied mechanics liens or material min liens affecting the property and is the subject of a bankruptcy. If seller receives any such notice prior to the close of escrow, seller shall immediately notify buyer. Seller represents that no tenant is entitled to any rebate, concession, or other benefit except as set forth in the rental agreements. Seller represents that the documents to be furnished are those maintained in the ordinary normal course of business, and the income and expense statements are and used by seller in computation of federal and state income tax returns, and then by signing below. Okay, so that's our tenant estoppel certificates. Anytime somebody occupies a property that's not the seller, that's what we would use. Any questions on that form? All right, moving right along, attached to that form, you'll see the rent cap and just cause addendum. Again, this isn't for us to investigate and find out what it is, but it's letting our buyers know that all these legal things could exist in that unit if they take on the landlord role. All right. Thank you so much, everyone, for joining me today. I hope this was helpful. Next week, we'll be back the same time. We'll be covering our cancellation of contract, our contingency removal for our buyers, our contingency for the sale of the buyer's property, and our notice to the seller to perform. As well as if you have any questions about other forms or buyer-related forms, you can always bring those questions to class as well, and I will answer those for you. And then at the end of the month, we are having our wonderful attorney back, Bob, talking about how to stay out of court. Again, those are always good classes. He always touches on something new and exciting that we may not have thought about and to be able to protect ourselves. So he'll be back at the end of the month. Any questions before we wrap up today? All right, everyone. Thanks for joining me and have a great day. We will see you next Thursday.
Thank you.